Good afternoon, everybody. Thank you for joining us for the Golden Gate RIMS educational webinar for May. Today's topic is California Workers' Compensation Reform, Senate Bill 863. A couple of housekeeping notes before we get started. First, if you've dialed in by phone but haven't logged in by web and you'd like to see the slides that will be presented, please point your web browser to readytalk.com. In the box where it says Participant, Join a Meeting, use the same access code that you used to join this call, 987-9821. We have muted the phone lines, so if you have a question during the talk, please use the Raise Hand button, which will let me know to unmute your line, or you can type a question into the chat box, and I will relay it to our presenter at the appropriate time. I'm getting a message that the phone volume is a little soft. I will try to speak up, and luckily our presenter is on a different phone system, so we hope that that won't be a problem. If it is, please do let me know by chat, and we will try to adjust. So our presenter today is Mark Priven. Mark Priven is Director for Regulatory and Alternative Risk Consulting with Bickmore. An actuary with extensive experience serving both public and private agencies and pools over the last 15 years. He serves on numerous professional boards and commissions and is a frequent speaker at industry conferences such as RIMS, PARMA, and ASSE. Mr. Priven is on the WCIRB Actuarial Committee and was heavily involved with the California Department of Industrial Relations in pricing the expected impact of SB 863. Mark?
Yep, I'm here.
Wonderful.
Okay, so can you hear me okay, Emily?
I can hear you fine, and if anybody else is having trouble with the audio, please let us know via chat.
Okay, sounds good. So let's see, thanks for the intro, Emily, and thank you for Golden Gate RIMS for inviting me to do this webinar. As Emily said, if you have any questions as I go through, feel free to just to write them on the chat, and there'll be time at the end for questions as well. So as Emily mentioned, I was pretty involved in the negotiations of SB 863. I was hired by the Department of Industrial Relations to help them price it as it was going on. So as different proposals came from either labor or business or the DIR, and they were in the middle of the negotiations, they would call me and we'd try to work through the numbers so that we could all sort of agree on where things were going. So I'll try to give a little bit of background to the negotiations a little bit as well as I go on. So the first question, however, in terms of leading up to SB 863 is what does everything in this slide have in common? Not a lot of people get this. I've shown this slide to a lot of people, and most people don't get it. But the answer is the theme is upside down. So you have Spider-Man's Upside Down Kiss. That is the cover to Diana Ross's famous disco hit, Upside Down, which people of a certain age like me will remember fondly. You have Grandma's Upside Down Cake, and then you have the California Workers' Comp system prior to reform. That blue line on the bottom shows that the permanent partial disability benefits per claim, per permanent partial disability claim, in California were about 30% lower than they were than the average for the other states. And on the other hand, the actual cost, the filed rates that insurers were living with were more than 50% higher than in other states. So the basic message is the costs in California were much higher than average, but the actual benefits that were going to injured workers were much lower than average in terms of permanent partial disability. So really I think the genesis behind this reform was to try to rebalance things with, I think, an emphasis on the permanent partial disability. So one of the goals was to increase permanent partial disability benefits to rebalance them without increasing costs, overall costs, and actually having some decrease in costs. But it wasn't like prior reforms where really the goal, a big part of the goal was to decrease costs. It was really to rebalance things, to increase PPD benefits without adversely affecting costs. So just to dig a little bit behind the behind the costs and the rates, why they're so high. The first thing is medical. It's a very high percentage of the total cost compared to other states, and also extremely slow to pay out. In California, medical claims just go on and on and on compared to other states, and I'll show that later. And also, we just have a lot of frictional costs, a lot of loss adjustment expense. That's, it's cost that doesn't go to the injured worker, it doesn't go to the doctor. It's just part of the cost of doing business. So digging into the medical, one of the questions when it comes to why medical costs are so high or have been inflating so much in California is whether it has to do with the average cost per procedure or whether it has to do with utilization. And I think the answer is clearly utilization. This slide here shows California workers' comp costs almost like a CPI where you have a basket of goods and you look at that same basket in 2002 versus 2011, and 100 means that the costs in 2011 were the same as in 2002. And you can see that really overall for that same basket of, again, this is California workers' comp specific, overall the costs were up by 5%. That's what that 105 represents in that top bar. So you take the same basket of goods, medical, California workers' comp goods in 2002, price them again in 2011, and they've only gone up by 5%. So clearly what's been happening in terms of the comp inflation is that two things. One is people are changing goods, so they're getting different medical services than they used to get, and also they're just getting more medical services than they used to get. But actually, again, on a basket-to-basket basis, the fee schedules have kept the average cost in line. The second thing on the medical cost is the payout pattern. So what these top lines, ignore the dotted line here, but the top lines represent for all 50 states the medical payout pattern. And under year of injury, you can see like that top blue line is about 45%, which means that there's one state where 45% of the total medical costs are paid in the year of injury. On the bottom there you can see the 15%. That means that the lowest of all the states, only 15% of the total medical costs are paid in the first year, and then you have the sort of percentile breakout in between the red and green lines. And you can see that for California, that dotted line, we are actually the slowest paying of all the states. In terms of in the first year, we have the lowest percentage of our medical costs paid in the first year. In the second year, we also have the lowest of all the states. And then of course when you look at the subsequent years, we have the highest. So our claims just seem to go on and on and on compared to other states. And the reforms, by the way, are looking to address this. I mentioned in addition to medical costs that another source of costs within the California system that are sort of out of proportion are the loss adjustment expense and what I'll call other frictional costs. So this slide shows the medical management and cost containment costs per indemnity claim by accident year 2005 through 2009. And you can see that red line at the top, which is where the losses are valued as of 24 months, the costs are increasing on average 24% per year. And at an earlier valuation date, as of 12 months, they were increasing at 23% per year. So a big problem is that the medical cost containment has been inflating at a very, very high rate. Also, allocated loss adjustment expense. By the way, when I talk about medical cost containment in the prior slide, I'll just go to that for a second, that's mostly bill review and utilization review. In this slide here, allocated loss adjustment expense is primarily legal fees. And you can see this is increasing at a pretty high clip as well, not quite as high as the medical cost containment, but certainly in the 10% sort of on average, 10%-ish or a little bit less per year, a very high rate compared to the overall inflation rate. So we have allocated loss adjustment expense, or ALAE, increasing at a high rate. And not surprisingly, part of what's driving that is increasing attorney representation. So since this is Golden Gate RIMS, I'm assuming most people here are from Northern California, and we take some regional pride, of course, in having things a little less crazy up here than they are down in Southern California. But you can see that blue line, which represents Northern California, in the 2009 year, our litigation rates were not that far from where LA and the rest of Southern California used to be. So we're still lower than Southern California, but that's because Southern California has continued to increase. But we're actually pretty close to where they were several years ago. So litigation has increased both in Northern and in Southern California. And overall loss adjustment expense in California is nearly nearly the highest of any of the states in the country. So these blue lines represent loss adjustment expense, both allocated, the legal stuff, and unallocated, which is mostly claims handling expense, as a percentage of loss. And you can see that the lowest of all the states, that percentage is 13.2. The highest is 26.4, and the percentiles in between. And California is very, very close to the top. And that was on a path to exceed or to once again lead the nation, given how fast loss adjustment expense costs were increasing every year, especially in comparison to, say, indemnity costs, which were not going up very much at all. So again, this is all sort of background to what the reforms were trying to address. As I mentioned before, medical costs high, claims handling expense high, but our permanent partial disability benefits were actually quite low. Again, this shows the various the states in terms of the average ultimate benefit for a permanent partial disability claim, and you can see it ranges at a low of roughly $20,000 per claim to the 80th percentile, roughly $60,000 to $70,000 per claim. And for every year, California was really in the lowest 20% of all the states. So, so that would be, I guess, the bottom 10. Out of the 50 states, we were in the bottom 10 for consistently every year. And you can see with SB 899, which was implemented in 2004, 2005, we even before that we were on the low end, but then we dropped even within that low end. We dropped to a lower part of the range, and again, I think this is part of the impetus of the reforms that that our permanent partial disability rate benefits were so low compared to other states, even while our overall costs were high. Lastly, this on the pre-reform stuff, this pie chart just breaks out where the total dollars go, and this is in the insurance world, where the insured dollars go. And what's interesting to me about this slide is you can see in the green the loss adjustment expense is 21% of the dollars, and the indemnity, which would be both temporary disability and permanent disability benefits, were 22%. So we were, prior to reform, very, very close to actually spending more adjusting claims than we were in direct payments to injured workers for their injuries. So now I will jump into the reforms. So there were several parts of the reform, and the major components were permanent disability benefit increases, and what I've outlined here is what each of the pieces are and what the estimated dollar impact was as estimated by the Rating Bureau. And so what you have in general is a huge increase in dollar-wise in permanent disability benefits offset by decreases in all sorts of other areas. So part of the offset was the elimination of permanent disability add-ons, eliminating the bump up and bump down, which was again related to permanent disability benefits bumping up or down based on return to work. Liens, which is a huge issue, which I'll discuss later, surgical implant hardware. This relates to the pre-reform problem where the medical providers were getting sort of were able to double bill for some of the hardware related to surgical implants, thus not only creating an additional cost in the system because the system was paying twice for the same hardware, but also creating an incentive to do these sorts of medical procedures, which are very costly. The ambulatory service center fees were addressed in the reform, independent medical review, the Ogilvie decision, which I'll touch on later, but basically there was a change to the future earning capacity or FEC factor, which addressed Ogilvie and medical provider network strengthening. So all of these issues sort of taken in combination, the goal was to have all the savings from all those different issues offset the increase in the permanent disability benefits. And I'll note that the permanent disability benefits actually roll in over 2 years. There's one in 2013 and there's another in 2014. And part of the reason for that is that there was a recognition that it'll take a while to implement a lot of these cost-saving reforms, and so they felt like if they put in all the increases right away, that there might be an imbalance in the first year where the cost increases would outweigh the decreases, and so they wanted to sort of phase in the PD benefit increases. And so you'll see, so this slide represents just what's happening in 2013, and then the next slide represents what's happening in 2014. So in 2014 you have all the things that were already implemented in 2013, the 6.3% savings, and then you have some additional PD benefit increases, again resulting in an overall savings, but less of a savings in 2014 than in 2013. So I'm monitoring the board. I don't see any questions yet, but feel free to write any questions as I go along. Bill Zachary. Yes, you can get a copy of the slides after the presentation. Right, Emily?
Yes. If anybody would like a copy of the slides, they will be available.
Okay.
And also the presentation is being recorded and will be available on the web.
Okay, great. So in addition, I just want to mention that there are several parts of the reform that were not quantified. We just were not able to come up with a way to reasonably estimate what the impact of these provisions would be. So we basically just punted on these. So not to say that these aren't potentially big, particularly RBRVS, but until we know exactly what it looks like and how it's going to be implemented, we really can't price it. Okay. Now let's go into the changes in permanent disability. So what I have here on the right is a little bit of a graphic that shows how the PD awards are calculated. And I want to break this out because different parts of how the award is calculated were impacted by the reforms. So we start out with the impairment rating, which comes from the doctor, and then potentially add-ons. So particularly the reforms wanted to address specific add-ons. And then there are some adjustments. One is the future earnings capacity, or the FEC factor. And what that does is it's a factor that ranged anywhere from 1.1 to 1.4. And it's simply you multiply the impairment times that 1.1 to 1.4. And it's meant to adjust for the fact that certain injuries, certain types of injuries, result in higher lost wages than other types of injuries. And so you could have two injuries that have the same impairment rating, say the same impairment rating of 20, but if it has to do with the eyes, that may have a different impact on your ability to earn wages than if it has to do with your knees. And so that future earnings capacity factor is meant to adjust for that. Another adjustment is the age. So you could have the same impairment, but if you are 65, you will end up with a different PD award than if you're 20. You'll have a higher one if you're 65 than if you're 20. So there's an age adjustment factor that goes in between the impairment and the award. There's an occupation adjustment. And so all those three go into, again, calculating what your final PD award is. Similarly, there's adjustments for apportionment, and then for a particular PD rating, there's a schedule of how many weeks of benefits you get, and that is not a straight line. So for example, the 1% of benefit that's a difference between a 60 and a 61 gets more weeks than that 1% of benefit that's between a rating of a 1 and a 2. So it's sort of a graduated benefit change. Then there's the min and the max benefits per week that are calculated or that are part of the regulations. And then of course we have life pension, permanent total, and bump up and bump down information. I'm going to stop for a second because I see some activity on the board. Okay, so Bill's saying that switching from the official medical fee schedule to RBRVS would probably result in an increase in cost, not a savings, but it's still important. That could be. I think the issue there for us in terms of pricing it is that we don't even know what the new RBRVS schedule would look like. And so until we have some idea of what it would look like, there's really no way to price it. Okay, I'll just keep going. So I'll mention, when we looked at changing the permanent disability benefits, the rule of thumb which emerged over time, which is that there can be no losers. And by the way, this is a picture of my daughter here with a Cal sweatshirt. What I mean no losers is what we were looking at is increasing PD benefits, and we did not want anyone to get lower PD benefits. And so sometimes when you overall increase PD benefits, but you change the system by which the benefits are calculated, you can point to specific people or specific demographics of people and say, okay, well overall benefits have increased, but this particular type of person with this particular type of injury will now get lower benefits. And what we experienced was that that was going to make the legislation very, very difficult to pass, because people would say, people would point to those particular demographics of people or injuries and say, this isn't fair, these people are getting less, and so don't vote for this bill. And so really one of the operating procedures as we moved along was that there could be no losers, and I'll explain how that impacted the reforms a little bit. The first one is that the future earnings capacity factor. So I mentioned that that's somewhere between 1.1 and 1.4. Originally when we were looking at this, we thought that we would just take it away and replace it with an average factor of something like 1.25 or 1.26. We calculated what the average was, and we just thought we're just going to replace it with that. Well, the problem is that those who had a high FEC factor of 1.4 or somewhere near there were going to lose out if we replaced it with a middle factor of 1.25. And so, for example, that's why I have a picture of this big ear here on the slide. People with injuries related to psych, respiratory, and hearing, which is why the big ear is there, those categories of injuries had high FEC factors of 1.4 or close. And those people would potentially have received less benefits if we replaced the FEC factor with an average one. And so in the final reforms, rather than replacing it with a 1.25, 1.26, we replaced the FEC factor with 1.4. So that means that nobody could lose out some people gained; those were at the low end of the scale gained, but nobody lost out because everyone was at least getting the 1.4 factor that they used to get. Secondly, the age. So the age adjustment. That is actually my grandmother. This is the Priven family slide, by the way. What some of the research showed is that actually age is not necessarily correlated with higher or lower permanent disability earnings, or higher or lower wage loss due to a permanent disability. And actually you could argue that a younger person for the same injury, for the same whole person impairment, should get a higher PD award than an older person, because if they both lose the same capacity to earn money, that younger person will ostensibly lose out for a longer period of time than an older person. And so you could argue both ways about whether the age adjustment should actually, a younger person should get more or an older person should get more. But we looked at getting rid of it. But the problem was, again, using this, sort of criteria of having no losers. If we got rid of it, then clearly people who are currently benefiting from it, which is older workers, would have lost out. And there was no way that legislation that hurt older workers was going to go anywhere. And so in the end, even though we thought maybe in theory, it made sense to not have an age adjustment factor, politically there was absolutely no way that that was going to change. And so we left the age adjustment factor in there. The same thing with weeks of benefit. The research shows that actually there is sort of a one-to-one relationship between that 1% of impairment, between a 0 and a 1 versus a 60 and a 61. That it really theoretically makes sense to have just a straight line in terms of how many weeks of benefit you should get for every point of PD, as opposed to having sort of a graduated scale where you get more points when you get more weeks of benefit per point of PD at the upper end with more serious injuries. Again, we could not straighten that line without hurting those who have higher PD ratings. And so even though in theory it made sense to have just a straight number of weeks of benefit for every point of PD, regardless of whether it's a more serious or a less serious injury, we couldn't touch that scale. So that's just some examples of how sort of the politics, I guess, or how some of the criteria that we developed over time impacted sort of the public policy of what we could put in the reforms. Okay. As far as how the PD benefits actually broke out over time, or the impact that they had, really most of the increase in the PD costs are associated with the increases in the maximum and the minimum benefits. That's really where the dollars are, where the majority of the dollars are in terms of the permanent disability benefit increases. There were some savings by eliminating some add-ons. This is one of the rare occasions where there are losers. People who in the past did these add-ons and are not able to do them anymore in the future, you could argue their benefits will be less, but I think that the feeling was that these were just, there weren't enough controls on being able to include these add-ons, and so they needed to just be eliminated. So I have here that the proposed savings from eliminating the sleep, sex, and psych add-ons. And lastly, the impact of increasing the FEC factor from a scale, which was somewhere between 1.1 and 1.4, to just replacing it with a 1.4 AMA modifier. That was about 13% of the PD cost. I mentioned also that the bump up and bump down were eliminated, and this graphic shows how the sort of the dispersion of bump ups and bump downs prior to the reforms. So, these blue columns here are all the claims that did not have any bump up or bump down, and you can see the red had the up and the green has the down. So on average, I think there were about 3 or 4 bump up in relation to bump down. So eliminating the bump up, eliminating this whole process was a savings to employers and insurers, because on average in the past, prior to the reforms, there were more bump ups than there were bump downs. And this is the information we use to evaluate that. Liens. So the interesting thing is, what was implemented in the reforms was there's a $150 fee for liens starting January 1st, 2013. And the nice thing about looking at what the impact of that would be is that we actually had some history, some very clean history on what a filing fee would look like. So this graphic here shows the number of liens filed per month up through, you can see through 2004, 2003. There's sort of 3 periods here. There's 2004 or March 2004 and prior, where there was sort of a big increase. And then you have from there, and then there's a big dip, and that dip remains through the middle of 2006. And the reason for that is that in January 1st, 2004, as the graphic shows, there's a $100 filing fee. So 2 things happened. First, there was a big spike right before January 1st, 2004, where everyone wanted to get in all their liens before the filing fee hit. And then there was this extended period where there were a big drop in liens. And then the filing fee was repealed in the middle of 2006. And then you see immediately a big jump in the number of liens. So we had some pretty strong evidence based on the past that a filing fee would impact the number of liens filed. And so again, we use this past history as a way of predicting what would happen. Now, keep in mind that there was in the prior graphic there was a big spike in the number of liens just prior to the implementation of the filing fee. So no surprise here. In California, we saw a big spike in the number of liens filed in the 3rd and 4th quarters of 2012. Now there was an additional fee that was implemented to try to mitigate this, and my opinion is that it did, and there was a lot of money. There's been a lot of money collected because of those fees. But nevertheless, there was a big spike, and you can see here. Well, first of all, what's really interesting is this. To me, this graphic breaks out the liens between LA County, the blue bars, LA Basin, other than LA County, in the red bars, and everyone else in the state, which is the green bars. So clearly, I mean, you hear this all the time that Southern California is sort of is ground zero for liens, and this really illustrates it. I mean, LA County and LA Basin are really overwhelmingly where the liens are. That's the first thing. And then the second thing is that there was a spike. It increased in the 3rd quarter of 2012. And remember, this was sort of being negotiated during that quarter, so people were probably preparing. And then there was a huge spike in the 4th quarter of 2012. In fact, there were more liens filed in the 4th quarter of 2012 than in all of 2011 combined. So a big spike in anticipation of the implementation of the lien reform. And then the last slide I want to talk about in terms of liens is regards the distribution of liens. So this pie chart shows what types of liens have been filed or were filed in 2012. And I think this is a particular concern because of the relatively new issue that's come up regarding petition for cost. I hadn't even heard of this term as of a few months ago, but it's come up as a way for people to basically file what looks like a lien and smells like a lien, but to get around the lien filing cost. And in particular, it can be used for interpreter and copy service liens, and that's sort of where it's been headed. And so I just thought it would be interesting to show people where the liens have been. So you can see interpreter liens were about 10%, copy service rounded were very small, almost 0% of the total liens. So that's where, those are the ones that are most likely to be impacted by a petition for cost. I believe there was a legal decision not that long ago in the last couple weeks that explicitly said that medical legal liens are not subject to petition for cost, and that's why I have that over on the left, that no petition for cost. So I know there's been a lot of concern about petition for costs that really came up after the implementation of SB 863. The way I look at it, as long as it's contained to interpreter and copy service liens, it should affect a relatively small percentage of the total liens. Okay, so I mentioned before that one of the guiding principles is that there should be no losers. So now I just want to mention specifically who I think some of the winners from the reforms are, and two that stand out. One are people are the employers and insurers that concentrate in Southern California, which again, as I mentioned before, was sort of lien central. I think that to the extent that the liens problem has been addressed and cleaned up, I think that they will really benefit even much more than the rest of the state from that. The other folks who benefit, and these are the injured workers, are those that used to have a low FEC factor. So if they had an FEC factor of 1.1 or close to 1.1, and now they have an FEC factor of 1.4, or not an FEC factor, an AMA modifier of 1.4, that's a 30% or close to 30% increase in their PD rating. And so, again, those with low FEC factors gain quite a bit. So on the right there, you can see is kind of this bizarre graphic of eyes and hands and so forth. But the reason is that the types of injuries that had low FEC factors were those that involved visual, nose, throat, hands, feet, ankles, and knees. And so, those are the ones who gain the most. In addition, the people who gained quite a bit were people who were at the min or max in terms of their wages, were at the min or the max of their of the PD benefits, because those mins and maxes went up quite a bit. If you happen to be in that in between, where you were in between the min and the max, well then obviously you may not be impacted by a change in the min and the max, and so you're not going to see quite the same bump that those who are at the min or max got. Okay. Independent medical review. This was extremely difficult to analyze because it's really a change in the process, and it's hard to really tell how a change in the dispute resolution process will impact costs. So the best we could really do is look at other places that implemented something similar, and really Texas seemed like the best candidate. Again, this is really going out on a limb. It's not nearly as clean as some of the other analyses or some of the other data that's provided early in this presentation about what the impact might be. Here we're just looking at other states and seeing what happened there. So it turns out in Texas, back in 2003, I believe, they implemented some reforms which included, among other things, a change to their dispute resolution process, which looks a lot like IMR. Again, this isn't a perfect comparison because they implemented a few other things other than what would be close to our IMR, but it's the best we could get. And so the next few slides are just going to show what happened in Texas after they implemented their reforms. The first thing is you can see the blue lines. Okay, what they call TIB is is the temporary income benefits. Those are what we would call temporary disability benefits, or they're similar to our temporary disability benefits. So the first thing is that they had higher temporary disability benefits. They had higher return to work. I'm sorry. They had lower temporary disability benefits. That green line shows that the actual dollars decreased, but they had better return to work within 6 months, which is the blue bars, and they also had more injured workers getting initial care within 7 days. So it's kind of what you would want to see. You'd see more immediate medical care, more people returning to work, and as a result of those, lower temporary disability benefits. As far as the impact on medical, you can see in 2003 the medical costs for professional and hospital went down and remained relatively flat after that. And then in addition, utilization went down. And as I mentioned at the beginning of this presentation, really utilization has been what's been driving the California workers' comp medical. So in particular, looking at what happens with utilization is important to see what might happen in California. Also addressing something we identified in California is the issue of how long California workers' comp claims tend to stay open, and that the medical, as I mentioned before, just keeps going on and on and on and on. In Texas, there really was a shortening in the development patterns and in the amount of time that payments were made on medical claims. And so the bottom bar, the blue bar, are the payments as of 6 months, and then the next one is 12 months and 18 months. And you can see at that very top one, the 24 months, prior to 2003, there used to be continued development, continuing substantial payments between 18 months and 24 months. But as you move to the right on 2003 and subsequent, you can see that those top two lines are very close. And what that means is that there are not a lot of payments being made between 18 and 24 months, so that sort of extended workers' comp tail actually decreased after their reforms. So it's possible that IMR will have a similar impact in California. And lastly, regarding the Texas experience and IMR, there was an increase in the number of denials for medical services immediately after they went to something similar to IMR. And that stayed up for a few years, and then people sort of adjusted to the system in terms of what they filed for and so forth, and then it went back down. So again, seemed like that the reforms that they implemented really did have an impact on medical care. Okay. I just want to highlight a couple other things. I've gone over sort of costs, but I just want to highlight again, I mentioned this before, but that the PD benefits are phased in over 2 years. There's some in 2013 and then others in 2014. That it's prospective only. And so it only affects injuries after January 1st of 2013. So if there's an injury that occurred in 2012 that does not have a rating yet, or didn't have a rating as of January 1st of 2013, the old PD schedule still applies. It doesn't. It's not retroactive. Of course, as I mentioned before, the impact on utilization, the impact of utilization is an area of dispute. As far as reductions, many of these are retrospective. So for example, the independent medical review, the lien changes, and so forth, if those are associated with claims that happened in December of 2012, and they're still open and they're ongoing and so forth, then IMR and the lien changes will apply to those. I think for IMR starting, it'll be implemented starting July 1st of 2013. So, but there should be some cost reductions that are retrospective on injuries occurring prior to 2013. On the other hand, the cost increases, as I mentioned before, on PD benefits will only affect claims from 2013 and on. Okay. Another thing I just want to mention here is that aside from the changes to the costs and the workers' comp system in general, there was also a pretty substantial change to the security requirements. And in the past, the security this is for self-insurers, for private self-insurers. In the past, the security requirements for private self-insurers were based on a multiple of case reserves. That either determined how much security had to be posted with the security fund or with the state, or the basis for the fee that had to be paid to the security fund for their ASP. And so I think two things with that. I think that one thing is that it turned out that multiple, which for many companies was 135%, meaning that the security requirement was based on 135% of case reserves. For many companies that in the end defaulted, that 135% wound up being inadequate. That's the first thing. And then the second thing is I think it was inequitable in the sense that those companies that had very strong case reserves, maybe the 135% was okay for them, or maybe it was even redundant, but then there were other companies that had very inadequate case reserves, and then that 135% was not enough for them. And so to have sort of a similar factor for all employers was really just not fair. It wasn't equitable between them. And so what they changed is that now the security requirement will be based on an actuarial study or on an actuarial estimate. And so I've had some friends joke with me that this is the Actuarial Full Employment Act, and now everybody wants to be an actuary because SB 863 made it so cool. And you can see here even Dwayne Wade and LeBron James, the current reigning NBA champs, are professing their desire to be actuaries. Maybe after they retire, I don't know. But they have a few exams to go, so we'll see how that works out. As far as measuring what's going to happen with the reforms, measuring the post-reform experience, it's going to take a while. This slide comes from the Rating Bureau, the WCIRB cost monitoring plan, and you can see this is for the indemnity benefits, and you can see over on the right everything here is 2014, some 2015, maybe one little thing that's 2013, but we are not going to know until at least the third quarter of 2014 what's going to play out with these indemnity benefits. So it's going to take quite a while to price. And the same thing on the medical side. I apologize, this slide's a little bit small or hard to read. But fourth quarter of 2013 is really the earliest that we're going to have any indications on most of the medical things. And then some of the medical is going to take until 2014. So I'm sure you and I and a lot of people have been getting a lot of questions already about, well, what's happening to the reforms? Is it working? Is it not working? And the answer is, we really don't know yet. I mean, we do know that the courts are holding firm with interpreting the liens the way they were intended and things like that. But in terms of actually getting lost dollars and claim counts and so forth so we can actually see the financial impact, it's going to take a while. And even after we have quantified, just a warning, even hindsight sometimes isn't 20/20. If you go back and look at the last major reforms, SB 899 and so forth, and look at the actuarial projections, even those that were done several years after, one of the things is that the claim frequency dropped much more than expected. I mean, it dropped by about over 30% for indemnity claims, over 30%, and the projection was about 11% drop. We still don't really know why. We know what we thought would happen according to our models of what happens when benefit levels change and so forth. We know that it dropped a lot more than that, but we just don't know why. And so, I fully anticipate that the same thing will happen with this reform, that there will be certain things that go higher than expected or lower than expected. And as much as we dig, we may not know why. As far as what's next, I think the issue of the high cost is still on the table. I think the reforms did a good job of rebalancing in terms of increasing PD benefits and having some savings, and that was definitely necessary. But even after the reforms, even with those savings, California continues to be a very high-cost state. In this graphic, the states that are dark blue have rates that are less than 50% of those of California. The ones that are light blue have rates somewhere between 50% and 100% of California's rates. So they're lower than California, but they're not. They're at least half of them, or at least half of the California rates. And then the lone green state, Alaska, is the only state that has rates higher than California. And so to me, this still points that there's still an issue with the overall cost in California. And the nice thing is that, I've said this before. I said this when I testified for the commissioner a couple years ago. All we want to do is just be normal. I mean, we don't have to be the best, the best state. We don't have to have best in breed or any of that. If we were just an average state with average costs and average permanent disability benefits and so forth, that would be just a great improvement. And so, here's to being normal. Okay. That's all my prepared slides, so I'm happy to take questions. I see Bill Zachary's been very active on the board here. I don't know if I should go through those or.
I'll go ahead and unmute the phone line so that people who have questions can ask.
The conference has been unmuted.
All right, the phone lines are open, and if anybody has a question, feel free to ask them now. And if we don't have any questions, thank you. I assume we don't have any questions from the silence. So thank you very much, Mark. Appreciate the presentation.
Sure, absolutely.
An email will be sent to the Golden Gate RIMS distribution list with information on how to get a copy of the slides and the location of where the recording will be uploaded and available. Thank you for joining us, and we look forward to seeing you again in the future.
Great, thank you.